Hello, ladies and gentlemen. My name is Cadet Sean Jolly, class of 2019. It's my privilege to welcome you to this session of the 26th Annual National Character and Leadership Symposium, made possible by our flagship supporter, the Class of 73, the Association of Graduates, the USAFA Endowment, and many generous supporters. We are fortunate to have 4 sitting justices from the Colorado Supreme Court with us today. Each have had incredible careers that exemplify integrity, service, and excellence. Ladies and gentlemen, it is an honor to present the Honorable Monica Marquez, the Honorable Brian Boatwright, the Honorable Melissa Hart, who will be with us shortly, and the Honorable Carlos Samour. Serving as our moderator for today's panel will be Professor Doug McKechnie from the Law Department here at the United States Air Force Academy.
Thanks, Sean. Good morning, everyone. It's my honor to be the moderator for this panel's discussion about leadership, teamwork, and organizational management. I use the word discussion purposefully because our intent this morning is that this be less of a monologue and more of an interactive conversation with our distinguished visitors. We'll be sure to reserve some time at the end of the session for Q&A, but please don't hesitate to request a microphone. We have runners here who will bring a microphone to you. Don't hesitate to request a microphone at any time during the discussion if you've got a question for the justices. So we'll reserve some time at the end, but we'd love this to be an interactive conversation. Before we begin, a couple ground rules for questions. The justices are unable to answer questions about previous decisions they've made, potential legal issues that could come before the court, and questions of a political nature. Now I'd like to quickly introduce the panel. Now the reality is this panel and the bios are just extraordinarily long, so I really tried to pick just a couple things about them that I thought would highlight the experiences that they have had before they joined the court. First, we have Justice Monica Marquez, who joined the court in 2010. Before joining the court, Justice Marquez was a Deputy Attorney General at the Colorado Attorney General's office, and she has served on various boards, including the Colorado Hispanic Bar Association and the Colorado GLBT Bar Association. Sitting next to her is Justice Brian Boatwright. He joined the court in 2011, and before joining the court, Justice Boatwright was a district court judge in Golden, Colorado, and he has served on various committees, including the Juvenile Services Planning Committee and the Children Youth Leadership Committee. Justice Melissa Hart, who will be joining us momentarily, joined the court in 2017. Before joining the court, she was a professor at the University of Colorado School of Law. She was also a law clerk for the retired Supreme Court Justice John Paul Stevens. And she's currently a commissioner on the Colorado Access to Justice Commission. Finally, Justice Carlos Samour joined the court in 2018. Before joining the court, Justice Samour was a prosecutor in the Denver District Attorney's Office and the Chief District Court Judge in Eastern Colorado. He's also the chair of the Colorado Supreme Court Model Criminal Jury Instructions Committee. So that all of them have lots of experience before joining the court and then some more experience on the court than others. But please join me in welcoming our guests. Justice Marquez, as the senior justice on the panel, the first question goes to you. What has been your biggest leadership challenge since joining the court?
I love that question because if you take a look at me, you wouldn't necessarily, in your own mind, think of someone like me as a Supreme Court justice. I joined the court in 2010, and when I joined the court, I was at that time 20 to 30 years younger than all of my colleagues. And so for all the other differences that I had, Hispanic, the openly gay, all of those pieces, the thing that mattered most or that made the most difference was that 20-year age difference. And trying to prove myself among those colleagues in a profession where wisdom and years of experience and gray hair seem to count for a lot. I didn't have, it's certainly not the gray hair. I'm working on that. I've learned a lot since then. And so I would say early on that initial challenge was just proving that I deserved to be there, that I was as competent as any of my colleagues. And that took a lot of day-to-day hard work and proving myself over and over again. I am now by virtue of a handful of unexpected retirements and other departures from our court, now the senior justice on the court, save for the chief. And except for Justice Hart, who's about 6 weeks younger than I am, I remain the youngest person on the court. So that piece hasn't changed. I've grown more comfortable with the role over time, but it has been a wonderful and interesting journey.
Justice Boatwright. One could easily describe the Colorado Supreme Court as a flat organization. All of the members have an equal vote when it comes to decision making. What unique challenges does that pose from a leadership and teamwork perspective?
Yeah, we were talking about how different we might be from how the military is structured. We're completely horizontal and all our votes count the same, and one person doesn't control the other. I mean, the chief runs the meetings, but he certainly doesn't tell anybody how to vote, or his vote doesn't count more. So I think in reflecting on it, I think what it causes us to do is have a collective wisdom, which I think actually is one of the strengths of our court. It forces us to listen to everybody's perspective and to take it into account. And I think one of the great strides we've made over the last 3 years, 4 years maybe, is we've gotten much more collegial in terms of how we work. And we will, if someone has a difference of opinion with regard to a decision we have to make, there's a lot of conversation ahead of time about if there's a common ground, and that has resulted in more productivity. But I think the biggest benefit is it forces collective wisdom. And sometimes it's painful when you're going through it, and you'll write an opinion, and then someone will write a dissent, and then you have to respond. And so there can be many drafts that go out before an opinion is finally produced, but it makes it better. It's like a refining product that makes it a better decision because it's a collective wisdom. One person doesn't control what happens. It has to be all of us.
So are there any lessons learned, any of you have learned in this sort of flat organization that you think might be insightful or transferable to a more hierarchical organization?
I would say, let my colleagues respond, is the benefit of collective wisdom. That, even with my law clerks, the first thing that I tell them is from day one, your job is to tell me when I'm wrong. I don't need yes men around me. I want to be told I'm wrong in my office before my colleagues tell me I'm wrong, before it goes out and people realize I'm wrong. So that listening to people is not a weakness. It's a strength, and having the character to consider other people's opinions and to make it a safe environment where you can disagree in a respectful way.
Do you want me to speak
Please.
about that? All right. Good morning. Thanks for having us. I would agree with what Justice Boatwright just said. And I'm the newest member on the court, so I'm the junior dude, and so I'm still learning. But one of the things that I quickly learned is that the decision-making process is really different at this level. I was in the trial court like Justice Boatwright before, and so on the trial court, I made all the decisions, right? They were my decisions. I didn't have to check with anyone. I didn't have to discuss them with anyone. I would talk to my law clerks, but ultimately, I made my decisions. Even when I sometimes consulted with colleagues, ultimately, I made the decision. And now, I don't make my decisions. I help make the group's decisions. So it's a group effort now. They're group decisions. And I think that makes them better because you have 7 different perspectives, 7 different backgrounds, 7 different people who bring something new to the table, something that the others don't. And a lot of times I'll go into one of our conferences thinking, oh, I bet everybody will be in agreement with me on this. And then you get in there and you start hearing what other people have to say and you think, I didn't even think about that, but that's a really good point. And sometimes, even if you don't have that reaction immediately, it at least makes you think and you get there eventually. And then you see where they're coming from. And then you realize, you know what, that's actually the better decision. And then you end up conceding, or it's okay to disagree as well, and that's why we have dissenting opinions, so that if we're not all on the same page, then there will be a dissenting opinion with the other position. But I think overall, it makes for better decisions, for sure.
So you were talking a little bit about having the conversations with your fellow justices, and there are, I assume, times when you find that you often agree with other justices. How do you avoid, to the extent that you might share similar judicial philosophies with some of your fellow justices, how do you avoid groupthink? How do you avoid sort of the tendency for people to agree when they often think alike?
When we prepare for oral argument, we prepare individually. We don't, I think that's one of the great protectors about that, because I think that coming into an oral argument not knowing how my 6 colleagues might approach a particular issue, I can learn from them during that questioning process. So that's one way we do that. 2, I think that surrounding yourself with law clerks who think differently. Welcome, Justice Hart. Justice Hart's daughter's 16th birthday is today, and I think she was trying to celebrate and spend time. So. I think surrounding yourself with law clerks who also come from different backgrounds and have different ideas can check you and your tendencies. Like Justice Boatwright, I tell my law clerks right off the bat, your job is to keep me from going over a cliff. You're my guardrails, and I want you to tell me when you think I'm wrong. So those are 2 ways that I think most readily help us, spare us from groupthink.
So one thing that I'll add here is, and something that I learned quickly, and Justice Hart did right before I got there, half a year before I got there. The way that we work in conference is that the most junior justice has to speak up first when it comes to decisions. And it's in part to avoid groupthink, right? What we want to avoid is the newest person going, yeah, I agree with you guys, right? I'm not going to go out on a limb and say what I really think because, I'm new here. So if you guys will think that, then you must be right. So it forces you as the newest member of the court to say first what you think and how you would vote and how you would decide the case. And then we go in order from most junior to most senior. So it'll start with me, then it'll go to Justice Hart, and then so on. And I think that's another way that we guard against groupthink. But I'll join what Justice Marquez and Justice Boatwright just said in terms of law clerks play a big role in our work. And I do the same thing that they do. I tell them, let me know when I'm wrong and why I'm wrong, right? I want to know. I don't want you to just agree with me. So here, let me give the microphone now to Justice Hart. Welcome.
Hello. We all sing our school fight song, so if you want to... No, just kidding.
I don't believe him.
Justice Hart, the question was how, oftentimes we see when we think about justices, they share sometimes they share judicial philosophies, and so where the question was, how do you all avoid tending to groupthink with fellow justices that you might share judicial philosophies with?
So I think it sounds like to some large extent that's been covered. I will say I still think about the first vote that I cast as a justice not a little over a year ago. As Justice Samour just said, I had to go first because I was the most junior justice. And I voted one way, and then we went around the table, and everybody else voted the other way. And I thought, oh gosh, maybe I'm not supposed to be here. I still think I was right, but I ended up deciding that it wasn't important, my correctness wasn't important enough to say anything. That what mattered at some point with what we're doing, what matters is that there's an answer to the question, and that you actually do have to decide when does it matter enough that I express my individual view about this, that I dissent, and when can I say, well, I think it should have come out the other way, but nobody else needs to know that because really we just needed to have an answer. And I think that's an important part of, it's not groupthink, it's just acknowledging that you're just one perspective in the process, and that part of what we do well is make decisions together, And that's part of why it's not just one justice court, but a 7-justice court.
And not that we need to weigh in on every question you ask, but I think this is really important topic that people need to appreciate. The bottom line is our philosophies don't necessarily matter. We are deciding what the law is regardless of what our personal feelings are, what our personal preferences are. Justice Gorsuch had a line in his confirmation hearing talking about it is, I can't tell you how many times I've have to make a legal decision that personally I didn't want to make. And so our philosophy doesn't matter.
Sometimes, in some organizations, it can feel like bureaucracy can hinder the goal of the organization or the mission of the organization. What types of issues do you all have to work through that might be out of your control, that might make it harder for you to get your job done?
I think the hardest thing for me was everybody has a different rhythm with which they get their work done. And nothing goes out until all 7 of us say, go. I mean, if it could be, as Justice Hart just said, she could be the only one that disagrees, but if she wants to write a dissent and it takes her a couple of weeks to write the dissent, it doesn't go out until it's done. And so, we have some of that formality, but as I mentioned, I think we're trying to kind of break down some of the barriers. We've looked at trying ways to speed things up. We were granting really long continuances, I think being too permissive with regard to that. And I think we focused on the fact that we need to get decisions made because they impact people.
You've each had a variety of experiences before you became justices of the Colorado Supreme Court. You've chaired commissions, you've been board members, academics, lower court judges. What are some of the most well-run organizations that you've been a part of, and why were they well-run?
Has any of us been part of a well-run? I think the Colorado Supreme Court is one of the most well-run organizations I've been part of. I was the referenced academic. I was a law professor for 18 years before joining the court, and academic institutions, I think, have a well-deserved reputation for not being well-run.
Company accepted.
Of course. We could all learn a lot from the Air Force Academy. But part of what I think makes our organization work so well is that despite the fact that there are lots of ways in which we could all become sort of enmeshed in our own egos, we get a lot of deference from a lot of people. I think all of us, and really everyone at the court, takes their ego out of the way and focuses on making things work. And that is something that I think is missing in a lot of organizations, and that really makes a huge difference.
Yeah, go ahead.
Just to piggyback on that, having been on the court for 8+ years and seeing the personnel change over that time, I've been through now multiple iterations, and every time you remove a personality or add a personality to that 7-person group, that dynamic changes considerably. I think the current mix that we have is wonderful because everyone does, despite our various approaches and various rhythms of getting the work done, we are all deeply committed to getting it done and finding ways to do it collectively and do it faster. I have appreciated that evolution, and I just think that we're in a good space right now. So I would count myself lucky to be in an organization where we regularly disagree, but we do so respectfully, and we do so in a way that continues to be productive, and that we don't, what's the best way to put this? We see so much in our society disagreement that reaches beyond disagreement. In other words, you have to not only disagree with the other person on the other side, but you demonize that person, you dehumanize that person. And I'm so grateful to be in an organization where that disagreement can occur, where we respect each other and assume the integrity of the position on the other side at all times. know that that other position has value. I feel very grateful to be a part of that.
If we could get a microphone over there so we can capture.
I can just repeat the question.
Okay.
The question was.
Go ahead.
Go ahead.
Okay. My question was just, could you expand on on specific techniques or even, events or things that you do to enhance that agreeing with this, agreeing to disagree, or how you navigate that space?
I think it starts with everyone's base agreement that everyone is coming from a place of integrity, an assumption that everyone is coming from a place of integrity, and that each of us is trying our best to come up with the right answer to a given problem. And trusting that, I think, helps you realize that there's value in whatever other perspective is being discussed at the table. We routinely have discussions at conference and even outside of conference when we're tinkering on different opinions or trying to bridge a gap between a majority and a dissent. We've had recent experiences where we meet offline and try to say, hey, this is why I'm concerned about this, or here's where, this is the specific problem I have, and just keep trying to come to some sort of agreement. Sometimes you can't bridge that gap, and sometimes you just have to agree to disagree. But there are many, many situations where we have been able to bridge that gap and work toward finding consensus, because I think it derives from a common commitment to getting that work out and a belief in that common mission.
I think relationships are key. Any well-run organization that I've been a part of, the people in the leadership positions have had good relationships with the people that they work with. And, I think the 7 of us are not best friends, but we have a really good working relationship. And I think that's key to working together, to being a team. And the other thing that I would point out is, maybe not in our court necessarily, but in a more typical organization, I think inspiring. I think if you're in leadership, you have to have a way that you can inspire the people that you're leading, to motivate them to reach the goals that they can reach, to work together to get there. So that would be the other thing that comes to mind in thinking about well-run organizations for me.
I think the other thing I would say, is we hold each other accountable. If someone were to write a dissent that we thought kind of crossed a line, I think that the other justices would go and say, can you think about how, they can say no, but you'd say, can you think about how maybe you articulated that position? I'm not sure that struck the tone that you were hoping to communicate. So I think we hold each other accountable and have a high expectation. The other thing that, piggybacking on what Justice Marquez said, is we got to live to fight tomorrow. I mean, I jokingly refer to it, we're in a forced marriage with 6 other people, and we got to get along, and we got to be productive. And it's the degree to which we're going to get along. But I don't think any of us are going to ever sacrifice the integrity of what we do is more important than who we are and how we work necessarily.
I also think you asked about sort of techniques, and one of the things that I think is so important about how we operate is we meet every Thursday morning to vote on what cases we're going to take and to have opinions come out the next week. That's what we call conference. So we meet in conference every Thursday morning, and then we go out to lunch after conference. And going out to disagreeing sometimes in like pretty vociferously at conference, and then just going out to lunch, that takes the edge off of the disagreement in really important ways. I remember once hearing former Congressman David Skaggs, who represented Colorado many years ago, talking about how he thought that one of the really unfortunate things that happened with our federal government was when Congress people stopped living in Washington, D.C., and their their spouses stopped interacting with each other because they had no reason to know each other because they didn't live in the same place. They lived in the 50 states, and they didn't have meals together, and they didn't have to take the edge off the fight. The fight was the only thing. And I think that that's a really important piece, is finding ways to take the edge off the disagreement, because we all need, as a parent of teenagers, one of the things I've also noticed is social media doesn't allow teenagers to take the edge off the disagreement, right? You never go home and have a break. You're always there. And that is, you have to find ways to back up and back away, because otherwise it's always raw. So I think that's something we do well.
And you kind of reminded techniques. The other technique I would say, and this is something we've improved on, is we're not emailing each other. We're face to face. I mean, we go in, and if we have a disagreement, we see if we can work it out face to face. And I think, when it's just different. It's a better way to communicate, obviously.
Great, thank you. Justice Hart, you brought up, when I asked about well-run organizations, you brought up egos. And I'm interested to talk a little bit more about that, because trying to be a good leader, trying to be a good teammate, and trying to run an organization well, sometimes you have to deal with big egos, and egos that sometimes are larger than they should be, or are inhibiting the mission of the organization. How do you deal with that? You sound like you all are very fortunate that you're able to leave, to a certain extent, egos at the door when you walk into the office, but how do you deal with egos in a teamwork and leadership, in the teamwork and leadership context?
I think I'm going to stick with what I started with there, which is, I think we all have to just agree to check our ego at the door. I mean, we all of us, and I think a lot of people in this room, most people in this room probably, have been told at various points in our lives that we're the smartest person in the room, or that we're exceptional in some kind of way. Oh, Carlos, I told you that yesterday. And I think you just have to recognize that A, it's almost certainly not true, and B, it doesn't matter anyway. It's not the relevant thing. And again, I think recognizing the mission of the court being not what I think, but what we think, and holding ourselves accountable and each other accountable to that.
To piggyback on that, when you write an opinion for the majority, you're writing for the court. You're not writing for Justice Marquez. And that's a really important thing to keep in mind. It's the work of the court. We also have sort of an informal protocol that you elevate others' work above your own. And so if someone else has a draft opinion coming through that you might potentially dissent on, you have to drop your majority work in order to focus your time and attention on that dissent, so that your colleague who's ahead of you in the queue can get his or her work done first. We are also all responsible for reviewing all of the opinions that come through, and that means you drop everything and take a look at whatever majority opinion is floating around and add your thoughts to it. But that's in service of this idea that it's the work of the court. This is not the work of 7 individual justices.
Final thing I'd say in dealing with people with big egos is not to engage in the battle of the egos. I mean, sometimes you just got to smile and absorb it, And then I'm not talking really, I think our court really does a very good job. I mean, we could not be less impressed with each other. I mean, in a way, well, you say, well, I'm a justice. Well, everybody is, okay, so it's no big deal. But we deal with a lot of committee work and things, and there are, at times there are. I actually teach the new judges, and I think probably there's bigger egos in the new judges because they haven't been humbled yet. And so sometimes they say stuff like, well, I always, and I want to go, when you have to look at your wristwatch to know how long you've been on the bench, don't always say always, okay? Never say always. So you just sort of smile and absorb it and don't engage it.
And Justice Samour, you mentioned relationships and the importance of relationships. Sometimes, as a leader, it's difficult to cultivate and improve relationships with those that you're leading, but also keep the leadership relationship intact. How do you do that? How do you make sure that you're building good relationships, but also keeping the relationship professional and appropriate?
Well, I think that's a good question, and I think that's something that probably came more into play for me in my prior position, because I was a chief judge of the 18th Judicial District, and I know there are some folks here from the 18th, and it's always great to see their smiley faces. So the 18th Judicial District in Colorado is one of the 22 judicial districts in the state, and it includes Arapahoe, Douglas, Elbert, and Lincoln County, so it's a huge area. And so, yeah, one of the challenges was, being the chief judge, I had to work with the chief probation officer, with the deputy chief probation officer, with the district administrator, with the deputy district administrator, a group of people who were part of the leadership team, right? And I had good working relationships with all of them, and I think those relationships were key to my leadership. But they also understood that, I had to hold them accountable, and that just because we had a good working relationship and we got along, didn't mean that they didn't have to do their jobs to the best of their abilities, and didn't mean that they didn't have to meet the expectations that were set for them. It didn't mean that I could get away with doing less than what I was supposed to do either. And so that's I think sometimes a tricky balance. But I think as long as everybody understands going into it that, what the expectations are, and you're still going to have good working relationships, and you keep some boundaries, right? And so I always was careful not to, I think it's good to have good working relationships and even be friends. I don't know that you want to become best friends, because then the lines start getting blurred. And so I always watch that. That doesn't mean that occasionally we didn't go out for a drink or for lunch, or if there was something to celebrate, we didn't celebrate together. But there were certainly certain boundaries that we all were aware of that we kept. And I think those were important, while at the same time, fostering the good relationship that we had. So.
You don't have anything to add to that? Okay, just as a reminder, if anyone has any questions, please just raise your hand, and one of the runners will bring a microphone to you. Looks like we have a question in the back. Thank you.
Hi, Claudia Howard, Department of Philosophy. Thank you so much for this. I was struck by when one of you pointed out that your job is to decide the law, and your personal opinions or your personal philosophies don't matter. And I wanted to ask, I guess, how your understanding has evolved over what the law is and what it does for us in our world over the course of your career.
I'm going to let Justice Hart in. I will say that it has evolved. I think as you get wiser, you understand what our role is in the process. And I find a lot of peace of mind in knowing what my role is in the process. And I think I would be doing more harm if I wasn't staying in my role of what I am doing. And so it has become more and more comfortable to me to realize that there's a process. And the other thing I would say is I've also learned that if I think something is going off the rails, with our checks and balances in our system, most of the time it comes back to equilibrium in a way, because that's why we have our checks and balances. And so, as a young deputy DA, I was outraged by the person who sped. Oh my gosh, we're going to prosecute this guy. And you get perspective on necessarily the bigger picture, but we take an oath to follow the law. And to me, I find great comfort in that. It allows me to do my job with a clear conscience, and I think that I would be violating that oath if I stepped outside of that lane. But that's a great question.
To add to that, keeping in mind that our role is simply to interpret the law as it's been written, and even if we don't like what's been written, to recognize that sometimes the opinion you have to write is to point out to the legislature, oops, this is what you guys did, and here's the impact, here are the consequences. We don't necessarily we can't rewrite that law. You have to trust that having issued that decision, the legislature can then do its job and fix that gap, plug that hole, make that change if it deems that's necessary. And I think I have too grown to trust the overall system and our roles within it, and to be careful not to tread on the roles of the executive, the roles of the legislative, just as we wouldn't want them to tread on our role either.
Final thing, the other thing I would say is, as I have matured in this, I've come to the conclusion that our forefathers were geniuses when they came up with this system and the Constitution and what that holds for us. So I just think that we would be doing damage if we went outside of that. So.
The only thing I was going to say is I think Justice Boatwright made this point, or this goes to the point that he made earlier, and that is that one of the biggest misperceptions about our court is that we make decisions based on what we personally think or our political views, and that's not the case. And so sometimes courts will make decisions and there will be reaction in the media or the public, well, that judge is so-and-so, or that court is so-and-so. Well, a lot of times we're making decisions where our hands are tied, and we're simply applying the law that the legislature has passed, as Justice Marquez pointed out. So now that doesn't mean that we don't it'd be naive to think that we're like robots. We're not, right? We bring, obviously, our personalities, our backgrounds, our experiences, all those things to the job. And so, but our job is to try to apply the law. And there are times when the law is unclear, and our job is to try to do the best we can to do justice and to work with what we have. But it's not to apply our own personal agenda or beliefs or thoughts. So hopefully that makes sense.
I'm going to give a concrete example. The first opinion that I wrote for the court, either last January or last February, was an opinion in an employment case. Before, as an academic, I taught employment discrimination law. I was a passionate advocate for workers' rights. Civil rights are where I live. And so when I started reading the briefs in the case, and it was undocumented workers who were not being paid what they should be paid by their employer, and I was like, wow, clearly the worker's gonna win on the first page of the brief. By the last page of the brief, I thought, oh, shoot, the worker does not win. It turns out the law, there's no way, even if I as a person in the world want the worker to win, that's just not what the law says. And it doesn't matter that I, as a human being, wish that these workers had been paid what they should have been paid. That's not an option here. And I actually think it's really important for any judge to be able to identify that case where you can say, I wanted outcome A, and I couldn't have it because the law didn't let me go there. And I think being able to identify those moments where you can say, I am specifically following my role rather than being the advocate that I might be if I were a lawyer or a non-judge, is an important way to know that you're doing what you're supposed to be doing.
Sir, we have a question down here in the front.
Barry McCann, Department of Aeronautics. Leaders of organizations sometimes have to make hard decisions between the needs or the desires or preferences of an individual versus the needs of the organization. And I think similarly, high courts from time to time have to make decisions between individual rights versus the greater good or the good of society. And that might be individual expression of religious beliefs versus protection against discrimination. Or that might be individual property rights versus urban planning requirements. So I'm interested in how would each of you approach those hard decisions, and what could we as leaders learn about how we ourselves could make those decisions?
I'd start at the last one.
Even before you get to the merits of a question like that. A similar process occurs with us in sifting through the 1,200 or so petitions for writ of certiorari that we receive. We pick and choose the cases that we're going to hear. We don't hear them all. We hear maybe 10% of those that are presented to us. And in that sifting process, we often have to decide to let go of a case where we might even perceive there to be error, because it's not worth the limited resources of the court to weigh into that particular issue. We are looking for cases that will have broad impact, that will be worth the time and effort it's going to take for the court to dive in. And one of the hardest lessons I had to learn early on in my experience was in letting that conveyor belt of petitions go by, seeing some go by where you realize that an individual probably got a raw deal, and being willing and recognizing that I have to let that one go for the greater good of, the efficient investment of the resources that we do have. So even before you get to those merits questions, you have to face some of those decisions on a daily basis. On the merits pieces, I don't know that there's a single philosophy that's going to guide all of those decisions. I think, at least for me, and I would imagine for my colleagues as well, in every case you're going to be thinking about the law. Do you think about the impact of decisions? Yes, absolutely. Does that weigh into it? Absolutely. But at the end of the day, you have to go where the law guides you.
And I would say one of the benefits of our job, one of our requirements, is we have to articulate specifically why we're coming to a decision. We don't get to say, we affirm this opinion, goodbye. We have to write out an opinion. So I think the message that I would send is, when you have to make a really difficult decision, explain it as best you can. And one of the things that we do in our opinions is we recognize the opposition voice to let them know that we've considered what their position is. And, it's always written in a way that hopefully reflects that we have considered perspectives and we've come to a decision. But the most frustrating thing for me now as a Supreme Court justice, having been a trial court judge, is when we just get these orders from the trial court judges say granted or denied. And then we got to figure out, did they abuse their discretion when we don't know why? And I think sometimes when people, it's like Melissa just referred to parenting. It's like to your kids, because I said so. I've never had one of my kids go, oh, okay, that's fair. You just have to go ahead and explain what the decision is. So.
I think we have another question down here.
Going back to the case where the law is unclear, how do you make a decision without letting your own personal beliefs intervene into that decision? What steps do you take?
I think one of the most important things in making a wise decision in a situation where the law is unclear and you don't want it to be based on your personal biases. And this is not just true for judges. I think it's any time you want to make the best decision without having your personal biases influence it, acknowledging what your biases are is the first place to start. So I think saying, okay, as I'm looking at this, my inclination is, the answer is X. Why? Why am I assuming that? Sometimes it's very clear, but in the cases as you are surmising where it's not clear, why did I go there immediately? And what are the best arguments on the other side? What are the things that are pulling me in that direction, and are they valid? And sometimes they will be, and sometimes you'll have to say, that's probably not, I'm probably not being totally fair. I'm probably not giving enough weight to the argument on the other side. And then I come back again to, thank goodness there are 7 of us, because that means even if I'm pulling in this direction, if other people can say, but Melissa, think about these arguments that you weren't giving enough weight to because of where you were coming from. Because we all come from somewhere. To pretend that we don't is making the first big mistake, I think.
In the process of writing, and this is in laying out the basis for your decision, sometimes that's where it will really crystallize, and you think this is the answer, but then as you try to write it, you realize it won't write. And that's when you have kind of this moment where you recognize, I'm going the wrong direction. And usually the correct answer will actually write itself much more easily. So that's another check for us.
Sir, another question down here in the front.
I had a question about the disciplinary board and your role in that. My understanding is that the office that manages the standards for attorneys in Colorado falls under the Supreme Court. Is that is your role more administrative, or do you play a role in the discipline?
Great question. So one of my administrative roles, along with Justice Hood, is to act as liaisons to the Office of Attorney Regulation Counsel. In general, the Supreme Court oversees and regulates the practice of law in the state, but we have a separate Office of Attorney Regulation Counsel that handles discipline complaints and also situations where unauthorized practice of law, so someone who is holding themselves out to be a lawyer but who is not actually licensed, they will regulate those complaints brought against those individuals as well. In that liaison capacity, we interact with the office in both an administrative and an adjudicative role. In the administrative role, we oversee the changing or amendments to the rules of professional conduct that govern the ethics for all practicing attorneys. In an adjudicative role, Justice Hood and I screen the discipline cases that come to us from the Office of Attorney Regulation Counsel. Typically, he and I, as a two-person team, can handle routine motions and things like that that come up. But if an attorney goes through the full disciplinary process and is sanctioned, that attorney has a right to appeal to the court, and that goes through the regular appellate process. So we get briefs, and sometimes we hold oral arguments, and we'll issue opinions in those decisions. Does that answer your question?
Question in the back?
Good morning, Your Honors. My name is John Legg. I'm a member of the Department of Law here. I wanted to ask you about judicial retention elections. It looks like, according to a brief Wikipedia search, that Colorado is in just under the minority of states. It looks like about 20 states have judicial retention elections. And I wanted to ask you about how your views on how you maintain your judicial independence with judicial retention elections, and maybe the merits of that as opposed to some other ways of selecting judges.
So I can say, so Justice Samour and I are the two of the four of us up here who will have to go through this soonest. I think the nice thing about our process, so the way our process works in Colorado, we're on your ballots. If you vote in Colorado, you'll see our names. But it's not, we don't have an R or a D next to our names, and we don't run a campaign. Thank goodness. I think elected judges, I don't think that's a great way to ensure judicial independence. I think keeping judges away from politics is a really good way to ensure judicial independence. So we're there, and we get voted on, and we get reviewed by a Judicial Performance Commission, but we're reviewed for the quality of the work that we're doing. Are we getting our work done promptly? Are we writing clear decisions? Are we respectful to lawyers and the parties in oral arguments? So it's really on the merits of the work we're doing, not in any kind of partisan evaluation. And that ensures that I can say for myself, I'll be on the ballot in 2020. What I think is, I better get my decisions done promptly. And I hope that that's what I'm thinking for my whole career, because really, I better get my decisions done promptly. And that's true regardless of whether my name is on a ballot or not.
I think it really strikes the right balance. I mean, you either have lifetime appointments on one end, and I think to me that there's the risk of a lack of accountability if someone has a lifetime appointment. Conversely, I can't imagine us running for office and raising money and having fundraisers and having that specter of favoritism and having the degree of accountability that politics requires. So, yeah, personally, would I love to have lifetime appointment? Absolutely, but it's not the right thing. It's not the right thing for our system. And it's structured in a way that it's kind of based on a volume of decisions. So county court, judges who make like 1,000 decisions in a week, get retained or stand every 4 years. District court judges who make, 100 decisions a week, stand every 6 years. Court of Appeals judges who make 40 decisions a week, stand every 8 years, and then we stand every 10. So hopefully it's not based on an individual decision, but it's a balance, and I think it's a really good one that we have accountability, but it's not going to be subject to hopefully not to an individual decision that we would make.
Question back here?
Yes, Mario Mendoza with the 18th Judicial District. Question I have is you spoke about communication, specifically with the emails. You said that y'all came together as a decision to say, we're not going to discuss this via email, it's going to be face-to-face. What was the lead up to that, and what were the pros and cons?
I'll answer since I said it. Well, first of all, when we conference, I've always conferenced in person. And I think what we've evolved from is, we don't send emails back and forth, we go down the hall. And I don't know that it's ever been necessarily the practice that we do emails. How it would happen is someone would write an opinion, and then someone would write a dissent, and then they'd revise their opinion and revise their dissent. And they would go back and forth, and that wasn't very productive. So now I think what we've evolved into is having a discussion up front if it appears that there may be some middle ground, and having that conversation. I was really more referring to the fact that attorneys, when they communicate by email, things can be perceived. Humor can be perceived as being sarcastic, and there's so much more that can be communicated by facial expressions and tone of voice, and there's just a higher degree of accountability when you're nose to nose with somebody and communicating. But it was more done necessarily, I think, in the opinions that were being written, and that would take weeks then instead of a conversation.
We usually conference immediately after oral arguments. So you walk into argument generally prepared, or at least leaning in some direction of how you wish to resolve a case. We talk about that case, and then typically, at least when I started, those cases would get assigned immediately. We've evolved to a system where the chief now assigns a whole batch of cases at the end of the week, and we're having longer conversations during those post-argument conferences to have a richer discussion and a better understanding of where every individual is. I think that's helped a lot and sped up the writing process because, again, when you are tasked with writing that majority opinion, you're writing for the court. You're not writing for yourself. You've got to capture the ideas of whoever is in your majority. And if you don't fully understand the nuances of that, and you don't understand where the dissent points lie, you're going to waste a ton of time in those initial drafts. So I think that process has sped up because we have chosen to meet face-to-face and have those longer conversations up front.
The only thing I would add is that, and I agree with everything that Justice Marquez and Justice Boatwright just said, but communication, I think, is key to leadership. And there are times when it's impractical, obviously, to have a face-to-face communication. The 18th Judicial District is a large judicial district. There are people spread out in 4 different counties, so you're not always going to be able to have a face-to-face. And if that's the case, then maybe a phone call. And even if you have to do an email, because you're communicating with a large group of people, and I used email a ton when I was chief judge because I had to. I couldn't go and talk to 40 people individually. But I think just taking the time to be as thoughtful as you possibly can in writing the email, I think it is really helpful. I would even have sometimes my staff read an email before it went out to everybody, right? And I would say, can you read this? You think anybody's going to take it the wrong way? And we would sometimes spend an hour on a 1-paragraph email or 2 hours, right? But I wanted to make sure that the right message was conveyed, that it had the right tone, that nobody was going to be offended, that nobody was going to take it the wrong way. And so to the extent that you have to communicate through email, and I think email is an important tool, then I just think, make sure that you're thoughtful about it and you spend time drafting it before you send it, especially if you're sending it to a group of people.
I'll just say, I don't think we have a formal policy, other than we meet in conference every Thursday, a formal policy about how communication happens, but bottom line to what Justice Samour just said, and to bring up something that Justice Boatwright said earlier, because we know that we are in this forced marriage to 6 other people, it's not the harm that would be caused by a thoughtless, quick email, or by not being clear and open about what we're trying to communicate in terms of not just the court, that's a big deal, but also just our day-to-day lives and our relationships is so large, and that we sort of have that top of mind always. You know that you can't walk away, and they're not going to walk away. And I think when you're in an organization where you know that's true, it really pushes you to be the most thoughtful communicator that you can be.
But by the way, I'm the only one that doesn't have a forced marriage, because these guys were all there when I applied. So I wanted to marry all of them. I chose them.
I think we have time for one more question. Last question of the day.
Your Honors, Cadet Martino from Squadron 10. I'd like to ask you, when writing an opinion that may disagree from public opinion, how do you maintain your judicial objectivity?
I think every one of us has had to write an opinion at some point or another that we knew was going to ruffle feathers or not be well received or just cause a stir. And I think that you have to, again, as Justice Boatwright said, be as thoughtful as you can to, in drafting your reasons for that decision, acknowledge the validity of the points on the other side so that the other side has felt heard and understood and had their fair day in court, if that makes sense. And then you just have to trust that you're doing your job. And a lot of judges have had to do some very brave things in accordance with the law that they knew would be contrary to public opinion. And that's part of the job, and you have to be okay with that.
I was going to say the final thing is then you just got to suck it up and know. I mean, that's your job. And it's not my job to make people happy. Not that I wouldn't want to make everybody happy. I'd want everybody to read it and go, he's right. But realize that's just not going to happen.
Well, Justice Marquez, Justice Boatwright, Justice Hart, Justice Samour, thank you so much for sharing your time with us today. We really appreciate it.
Thanks for having us.